This is not a drill. What I am about to share with you today could fundamentally change how you operate as a landlord in the United Kingdom. The Renters' Rights Act has just dropped a bombshell that nobody saw coming, and there are new clauses that are now being marked as mandatory, not optional, not recommended, mandatory. And if you are not paying attention right now, you could find yourself on the wrong side of the law within months. I have spent the last 2 weeks going through every single amendment, every clause, every piece of guidance that has come out of Parliament. I have spoken to solicitors. I have spoken to letting agents. I have spoken to landlords who are already panicking. And I am going to break it all down for you today in plain English because the mainstream media is not covering this properly, and most landlords have absolutely no idea what is about to hit them. Before I get into the details, I need to ask you something. If you own rental property in the UK, if you are thinking about becoming a landlord, or if you are a tenant who wants to understand your new rights, you need to be subscribed to this channel. I'm not asking for fun. I'm asking because the information I share here could save you thousands of pounds and keep you out of legal trouble. We are a small channel, but we are growing fast because we tell the truth about what is happening in UK property. So please take 2 seconds right now, hit that subscribe button. Tap the bell icon so you get notified when I post new videos. It costs you nothing, but it means everything to this channel. Do it now and let us get into this. Right, so what exactly has happened with the Renters' Rights Act? Let me take you back a few steps so you understand the full picture. This legislation has been in the works for years. It started life as the Renters' Reform Bill under the previous Conservative government, and many landlords thought it would quietly die or be watered down into nothing. That did not happen. When Labour came into power, they picked up the bill, supercharged it, renamed it the Renters' Rights Act, and they have been pushing it through Parliament at a speed that has caught everyone off guard. The core elements you probably already know about. Section 21, no-fault evictions are being abolished. That is the headline that got all the attention. But what most people missed, what most news outlets completely failed to report on, are the new mandatory clauses that have been added in the final stages of the bill. These are requirements that every single landlord in England will have to comply with. No exceptions, no grace period in some cases, and the penalties for non-compliance are severe. Let me start with the first bombshell. There is now a mandatory requirement for landlords to register on the new property portal within a specified timeframe once it goes live. This is not like the existing tenancy deposit schemes where you have 30 days. The government is setting up a national database of every landlord and every rental property in England. You will be required to register yourself as a landlord, register every property you let out, and keep that information updated. If you fail to register, you will not be able to serve valid eviction notices. Let me say that again because it is crucial. If you are not registered on the property portal, any eviction notice you serve will be invalid. You could go through the entire court process, spend thousands on legal fees, wait months for a hearing, and have the whole case thrown out because you were not properly registered. But it gets worse. The property portal is not just a registration system, it is an enforcement tool. Councils will have access to it. They will be able to see which properties are registered and which are not. They will be able to cross-reference with council tax records, electoral rolls, and other databases to identify landlords who have not complied. And the fines for failing to register are going to be substantial. We are talking about civil penalties of up to £30,000 for serious or repeat offences. This is not a slap on the wrist. This is financial devastation for smaller landlords. Now here is where I need to pause and say something important. If you are finding this information valuable, if this is news to you, then please do me a favour and share this video with another landlord. Send the link to your WhatsApp groups, post it on your Facebook, email it to your property investing friends. The more people who understand what is coming, the better prepared we all are. And while you are at it, if you have not subscribed yet, what are you waiting for? This is the kind of content that could save your property business. Subscribe now and let us continue. The second mandatory clause that has been added relates to the Decent Homes Standard. Now you might think you already know about property standards. You might think your properties are already compliant because they have gas safety certificates and electrical checks. But the Decent Homes Standard that is being made mandatory for the private rental sector is far more comprehensive than anything we have seen before. This standard was originally designed for social housing. It covers things like the overall state of repair, the age and condition of kitchens and bathrooms, the thermal comfort of the property, and whether the home meets the statutory minimum standard for housing. Under the new rules, if your property fails to meet the decent home standard, you could be prohibited from letting it out. Councils will have the power to issue improvement notices requiring you to bring the property up to standard within a specified time frame. If you fail to comply, you face fines, rent repayment orders, and potentially banning orders that prevent you from being a landlord altogether. And here is the kicker. The definition of what constitutes a decent home is going to be applied retrospectively to existing tenancies. You cannot claim that your property was compliant when you first let it out. If it does not meet the standard now, you are in breach. The third mandatory clause concerns Awab's law. You may remember BOMBSHELL, the 2-year-old boy who tragically died from respiratory problems caused by mould in his family's social housing flat. That case shocked the nation and led to new legislation requiring social landlords to address hazards like damp and mould within strict timeframes. Well, under the Renters' Rights Act, Awab's law is being extended to the private rental sector. This means that if a tenant reports damp, mould, or other serious hazards, you will have a legally mandated timeframe to investigate and begin remedial work. We are talking about 14 days to investigate and a further 7 days to begin repairs in emergency cases. For less urgent issues, the timeframes are longer but still strictly enforced. If you fail to meet these timeframes, tenants will be able to take direct legal action against you. They can apply to the courts for compensation. They can report you to the local authority, who can issue fines. And repeated failures will be recorded on the property portal, visible to prospective tenants and enforcement officers. Your reputation as a landlord will follow you everywhere. There will be no hiding from poor practice anymore. I want to stop here for a moment and address something directly. I know some of you watching this are thinking that these rules are unfair, that the government is making it impossible to be a landlord, that you are being treated like criminals when all you are trying to do is provide housing. I hear you. I understand that frustration. But here is the reality. These rules are coming whether we like them or not. The choice you have is not whether to comply, but how quickly you adapt. The landlords who prepare now, who get their properties up to standard, who understand the new systems, they are the ones who will survive and thrive. The landlords who bury their heads in the sand, who hope this will all go away, they are the ones who will be forced out of the sector. I am not here to sugarcoat things. I am here to help you succeed in this new environment. And that is why I need you to subscribe to this channel if you have not already. The content I produce could be the difference between you keeping your properties and losing everything. Hit subscribe right now. Let me move on to the fourth mandatory clause, and this one is going to affect every single landlord, regardless of how many properties you own. The new rules on rent increases are now set in stone. Under the Renters' Rights Act, landlords will only be able to increase rent once per year, and you can only do so through a Section 13 notice. The old method of using rent review clauses in tenancy agreements is being abolished. You cannot contract out of this. Any clause in a tenancy agreement that allows for more frequent rent, increases or uses a different mechanism will be void and unenforceable. But here is where it gets really important. Tenants are being given much stronger powers to challenge rent increases. If a tenant believes the proposed rent is above market rate, they can refer the matter to the first-tier tribunal. The tribunal will assess what the market rent actually is for that property in that area, and they will set the rent accordingly. In some cases, landlords have seen their proposed increases rejected entirely or significantly reduced. And under the new rules, the tribunal cannot set a rent higher than what the landlord originally proposed. So if you ask for too much and the tribunal disagrees, you are stuck with whatever they decide. There is no upside, only downside risk, and this is going to fundamentally change how landlords approach rent increases. You are going to need proper evidence of comparable rents in your area. You are going to need to document the condition and features of your property. You are going to need to be reasonable and realistic in your expectations. Gone are the days of putting rents up by whatever you feel like. The tribunal system is being beefed up to handle the expected flood of challenges, and tenants are being actively encouraged to use it. The fifth mandatory clause relates to the new grounds for possession. Yes, Section 21 is going, but that does not mean you cannot evict tenants. It means you need a valid reason. The Renters' Rights Act reforms the Section 8 grounds for possession and makes some of them mandatory. The most significant change is to the ground for landlord or family member occupation. If you want to sell your property or move into it yourself, you can still evict the tenant, but you cannot use this ground within the first 12 months of a tenancy. And if you claim you are moving in or selling, but then re-let the property within 12 months, you will face severe penalties, including compensation to the former tenant of up to 16 months' rent. There are also new restrictions on using the rent arrears ground. Currently, landlords can begin possession proceedings when a tenant is 2 months in arrears. Under the new rules, there will be stricter requirements and longer notice periods in some cases. The government wants to reduce what they call revenge evictions, and they are making landlords jump through more hoops to prove that eviction is genuinely necessary and not punitive. For landlords who genuinely need to regain possession of their properties, these changes add time, cost, and uncertainty to the process. The court system is already backlogged. Cases are taking 6 to 12 months to be heard in some areas. Add the new procedural requirements on top of that, and you could be looking at 18 months or more from serving notice to actually getting your property back. That is 18 months of potential rent arrears accumulating, 18 months of property damage, 18 months of stress and legal fees. This is the new reality, and you need to plan for it. Alright, I have covered 5 of the major mandatory clauses, but there is so much more in this legislation that I want to make sure you understand. Before I continue, I want to say thank you to everyone who has already subscribed. I can see the numbers going up, and it genuinely motivates me to keep producing this content. For those of you who have not subscribed yet, please do it now. We are trying to build the best UK property information channel on YouTube, and we cannot do it without your support. Every subscription helps the algorithm show this content to more landlords and property investors who need to see it. Hit subscribe, hit the bell, and let us finish this video together. The 6th mandatory requirement relates to pets in rental properties. Under the Renters' Rights Act, tenants will have a default right to request a pet, and landlords cannot unreasonably refuse. The word unreasonably is doing a lot of heavy lifting here, and it is going to be a source of significant disputes. What counts as a reasonable refusal? The guidance suggests that landlords can refuse if the property is unsuitable. For example, a small flat for a large dog, or if the lease or freehold prohibits pets. But simply not wanting pets in your property is not going to be good enough anymore. Tenants can challenge unreasonable refusals, and landlords who persist in refusing may find themselves on the wrong end of complaints to the Ombudsman. To balance this, landlords can require tenants to have pet insurance that covers damage to the property. But the costs of this insurance will be borne by the tenant, and there are already questions about whether adequate products exist in the market. What happens if the tenant cannot find affordable pet insurance? What happens if the pet causes damage that exceeds the insurance coverage? These are questions that the legislation does not fully answer, and landlords are right to be concerned. The 7th mandatory clause concerns discrimination, and the new rules are sweeping. It will be illegal for landlords to discriminate against tenants based on whether they have children or whether they receive housing benefits. No DSS policies are being outlawed completely. You cannot advertise a property as unsuitable for children. You cannot refuse a tenant because they receive universal credit or housing benefit. If you are found to have discriminated on these grounds, you face fines and compensation claims. Now, I know many landlords have had bad experiences with benefit tenants. I know the system for receiving housing benefit payments can be slow and unreliable. I know that some landlords have faced significant rent arrears from tenants on benefits, but the law is the law, and it is changing. You will need to assess each tenant on their individual merits, not write off entire categories of people. This is a significant shift in how many landlords operate, and it requires a change in mindset as well as practice. The 8th mandatory requirement involves the new Ombudsman system. Every private landlord in England will be required to join a government-approved Ombudsman scheme. This is similar to the existing redress schemes that letting agents are required to join, but it will now apply to all landlords directly. If a tenant has a complaint about their landlord, they can escalate it to the Ombudsman. The Ombudsman will have powers to investigate, to require landlords to take remedial action, and to award compensation to tenants. Membership of the Ombudsman scheme will be another mandatory requirement tied to the property portal. If you are not a member of an approved scheme, you cannot legally let property. The fees for Ombudsman membership have not yet been confirmed, but estimates suggest somewhere between £50 and £100 per year per landlord. Add that to the property portal, registration costs, the licensing costs in many areas, the increased compliance costs, and you can see how the financial burden on landlords is mounting year after year. Let me talk now about what all of this means practically for landlords in the United Kingdom. The cumulative effect of these mandatory clauses is to create a much more regulated, much more expensive, and much more risky environment for private landlords. The balance of power is shifting decisively towards tenants. The enforcement mechanisms are being strengthened. The penalties for non-compliance are becoming severe. Some landlords will look at all of this and decide it's simply not worth it anymore. They will sell up, take their capital out of residential property, and invest elsewhere. We have already seen hundreds of thousands of landlords exit the sector in recent years, and this legislation will accelerate that trend. The government may say they want a healthy private rental sector, but their actions suggest otherwise. Every new regulation, every new requirement, every new cost pushes more landlords towards the exit. For tenants, the picture is mixed. Yes, they will have more rights and more protections. Yes, rogue landlords will find it harder to operate. But as supply decreases and costs increase, rents will continue to rise. The tenants who the legislation is designed to protect may find themselves priced out of the market entirely. They may find it harder to find properties to rent as landlords become more selective. They may face longer waiting lists and more competition for fewer homes. The law of unintended consequences is powerful, and I fear we are about to see it in full effect. So what should you do if you are a landlord? First, start preparing now. Do not wait until the legislation comes into force. Get your properties up to standard. Review your tenancy agreements with a solicitor. Make sure your documentation is in order. Budget for the additional costs that are coming. Second, stay informed. The details of implementation are still being worked out. Timeframes may change. Guidance will be issued. You need to keep up with developments, and that is exactly why you should be subscribed to this channel. Third, consider your portfolio strategy. Are there properties that are going to become uneconomical under the new rules? Are there areas where enforcement is likely to be heavier? Should you be consolidating, diversifying, or exiting? These are questions only you can answer, but you need to be asking them now.
For tenants watching this, understand that these new rights come with responsibilities. You will have more power to challenge landlords, but you will also need to engage with formal processes, keep records, and meet your own obligations. The relationship between landlords and tenants works best when both sides act reasonably and communicate clearly. New laws can set the framework, but they cannot create good relationships. That takes effort from everyone involved. I am going to wrap up now, but before I do, I want to make one final appeal. This channel exists to help people navigate the complex and constantly changing world of UK property. We do not have big sponsors. We do not have a huge marketing budget. We grow through people like you watching, subscribing, and sharing our content. If this video has been useful to you, if you have learned something you did not know before, please subscribe right now. Click the subscribe button, tap the notification bell, and become part of this community. Then share this video with one other person who needs to see it. A friend who owns rental property. A family member who is thinking about becoming a landlord. A colleague who is a tenant wanting to understand their rights. Every share helps us reach more people and build a stronger community. The Renters' Rights Act is coming. These mandatory clauses are not going away. The landscape for landlords in the UK is changing fundamentally and permanently. The question is not whether you will be affected, but whether you will be prepared. I am here to help you prepare, but I can only do that if you are subscribed and watching. So do it now. Subscribe to UK Property Info. Together, we will navigate whatever comes next. Thank you for watching. I will see you in the next video where I will be breaking down the exact timeline for when these new rules come into force and what you need to do month by month to get ready. Do not miss that one. Subscribe now, and I will see you there.